I'm talking about unfair prejudice, which I suspect will be a remedy that's familiar to many of you in the room. The reason that this talk is titled Not Unfair Prejudice and skirting around the edges is not intended to be facetious in any way, but of course it's far easier when we get a case arrive on our desks where it obviously is something. When we can clearly see, for example, in a quasi-partnership type case, that a director who had joined the company assuming that they would continue to be a director and be remunerated by the company gets excluded, we can see that that's unfair prejudice. The far harder situation is when we get a case arrive on our desks where it's right on the edge of what might be unfair prejudice. That's a much harder place in which to advise, much more difficult for both the company to decide what to do about the allegation of unfair prejudice, and equally for the individual to decide whether they're going to start an action which is likely to be something that is expensive and will probably take some considerable time. So what we'll be looking at is areas that come up quite frequently in practice where you are at the outskirts of unfair prejudice and where you will need to exercise caution. So of course, in order to cover what is not unfair prejudice, I will need to touch briefly on what is unfair prejudice. And for that reason, in the handout, I've given you quite a lot more detail than I'll go through orally in this talk to try and assist with that question. And we'll then go through 4 examples that I hope will be useful ones where you'll be able to say, touch wood, following this talk, whether something is or is not likely to be something where your client should be either bringing a claim for bringing a petition for unfair prejudice or not doing so. The statutory remedy has been around for some considerable time and a long time before the Companies Act. It's previously been referred to as oppressive or reprehensible behaviour and equated to criminal type conduct. Now, what you should be looking for in any unfair prejudice case is a breach of the basis upon which it's been agreed that the company will be run. And the most straightforward place to find that breach will be within the Articles of Association or within a shareholder agreement. But the test is wider than that. So what we're told within the section itself is that if the affairs of the company have been conducted in an unfairly prejudicial manner, that's unfair prejudice. Doesn't help us, of course, with what unfairly prejudicial means. Or secondly, if an actual or proposed act or omission by the company will or has led to unfair prejudice, that also will get you home. One bit of good news I can give you is that in an amendment to the Act, subsection 1A was introduced, and where there has been a removal of the company auditor on grounds of divergence of opinions on accounting treatments or audit procedures, or on any other improper grounds, that will constitute unfair prejudice. So that is the one area where you can give certain advice to a client if you've had an auditor removed on divergence of views. In terms of the parties, the party bringing the petition needs to be a member, be that a member on the face of the company documents or a member by operation of law. By operation of law brings into the equation those who may inherit and those statutory officers who may need to take on conduct of a particular member's shareholding. And the parties will generally be the majority shareholders against whom the minority claim the unfair prejudice has been exercised, or maybe them. It may be the company itself, but the category of respondents is far wider than you might think, and can include those to whom monies have improperly been diverted, can include those who may have assisted in the diversion of funds. So when deciding who you should be naming as a respondent to an unfair prejudice petition, you will need to think not just about who may have conducted the unfair prejudice, but ultimately where the benefit may have gone, because that may well be really who you're seeking the final remedy against. Now, as was said earlier, the benefit of an unfair prejudice petition, or one of the benefits, is that there are a wide range of remedies available, and in truth the category of remedies are unclosed. The court can order the company to regulate its affairs in a particular way. The court can order the company to either do something or refrain from doing something. Alterations to the company's articles can be ordered. But the most common remedy, and one that we will hark back to in due course, is the remedy of a share buyout, where a minority shareholder can be bought out without a discount, and so they can leave the company that they say, through the majority, is subjecting them and others to unfair prejudice. Within the handout, I've provided you with a useful part of the judgment from, at that time, Mr. Justice Slade in Rebury Hotel Ventures, that is frequently referred to assist with the test for unfair prejudice, explaining to us that it's an objective test. That wording is referred to frequently, but for reasons that are beyond me, the case itself has never been formally reported. So you have the wording there. And when we look to go beyond the concept of, is there a breach of the Articles of Association, is there a breach of the shareholders' agreement, then the judge who has loomed large right the way across authorities from the time that he was a J through LJ to Lord is Lord Hoffman, who's given the majority really of the seminal decisions in this area. And what his judgments tell us is the category is wider than just looking at pieces of paper and breaches of documents. We can look for the expectations that have arisen as between the members of the company, and where those expectations are sufficient to found an understanding upon which the company should be run, a breach of that understanding may well be sufficient to constitute unfair prejudice. And the terminology that's been used for that is to look for equitable considerations and consider whether those equitable considerations, the kind of agreements, the assurances that have been reached between the members of the company, are sufficient to form a legitimate expectation upon which the company should be run. The key being, and in fact in the case of O'Neill and Phillips, Lord Hoffman indicating that his earlier description of legitimate expectations had been misunderstood, the key being that you must look for the evidence of those kinds of understandings first. You can't start off by saying, I had a legitimate expectation when I became a minority shareholder that the company would be run in this particular way. You must establish clearly the basis of that understanding before you get to the point of establishing a legitimate expectation that may have been breached. And for me, I found very helpful the words of Mr. Justice Parker in the case of Re-Guide Zone that I've given you in the handout, where he talked about the sort of terminology of estoppel, really. And so he said, look for equitable considerations where you have agreements and understandings in place as between the members, and then detrimental reliance upon those agreements and understandings by the membership. Once you have that in place and you then have a breach of those sorts of agreements and understandings, you're in the territory of where you may be reaching the equitable considerations that can lead to unfair prejudice. Now, for me, because estoppel is a fairly common concept for us lawyers, I found that a useful way to strength test arguments about equitable considerations. Is there sufficient there to form something upon which someone's placed detrimental reliance and understood the company would be run? If there isn't, you're potentially at risk with the argument you're seeking to raise for unfair prejudice. Finally, just to flag to you that I've given you in the handout some of the examples of the more common types of unfair prejudice. As I said, we're going to focus on what's not unfair prejudice, and so I'll move swiftly past those examples. So the first example of what is not unfair prejudice is where what is sought is corporate relief. And by that, I mean where the relief that's being sought is in fact a remedy for the company and not for the individual member, it's highly likely that what you're looking at is not an unfair prejudice claim. Now, I've tried on that slide to give you in 2 bullet points what I could probably have talked to you about for the vast majority of this afternoon and possibly more, which is the difference between a derivative claim and an unfair prejudice claim. Both are actions for minority shareholders. The one, you need permission from the court to bring it because you bring it on behalf of the company seeking a remedy for a company. It's one of the potential remedies for an unfair prejudice petition. But generally, if you're bringing a derivative claim, you're seeking a remedy where money will be paid to the company or where property may be returned to the company for the benefit of the company. In an unfair prejudice petition, generally, the relief that's being sought is likely to be personal relief for the member. What that means is you can frequently get it wrong, and people regularly do, because the kind of conduct that might lead to a derivative type claim is often the same kind of conduct that might lead to an unfair prejudice allegation. And so in Frambar Holdings, permission to bring a derivative claim was refused because the remedy that was sought was the sale of the claimant's shares at a fair price. And so what had been thought by the claimant in that case was, we want to bring a derivative claim for this. And the court said, no, look at the remedy that you're after. The remedy that you're after is a personal remedy, and you should be dealing with this as an unfair prejudice petition. Effectively, go away and try again. And no doubt a petition was in due course brought. In Hughes and Weiss, the case that I've put up there, corporate relief was sought, but the claim, the basis of the claim, looked a lot like an unfair prejudice petition. Despite the fact that it looked like an unfair prejudice petition, because the relief was corporate relief for the company, permission was given in that case to pursue the claim as a derivative claim. Now, of course, what could have happened is it could have gone through as an unfair prejudice petition, and the remedy at the end could have been, you're now granted the right to bring a derivative claim. That, of course, would be a very expensive way to get to the point of getting permission to bring a derivative claim. Far better to reach it through this route. So, starting point, point 1, it is not an unfair prejudice petition, or highly unlikely to be something that it makes sense to bring as an unfair prejudice petition, if what in truth you're seeking is corporate relief for the company as opposed to individual relief for the member. The next example of what is not unfair prejudice, and again something which I've seen in practice where papers have landed on my desk, they don't land on desks anymore, landed in my inbox for advice on whether or not we're looking at an unfair prejudice case, is where you can demonstrate one or the other of unfair and prejudice. If you can't demonstrate both, it's likely that your petition will fail. And so a couple of cases that illustrate those issues well. Rock Nominees was a case where the directors of the company had transferred an asset from the company out of the company in circumstances that the Court of Appeal described as them acting in hopeless conflict. Fairly strong terminology from the Court of Appeal. Quite clear that what they were doing, if they're hopelessly conflicted, is unfair. The problem was the price that they'd achieved for that asset was a good price. Had the company sought to do it in a proper way, they couldn't have done any better. And so notwithstanding that you had clear unfair conduct, no prejudice. Can't succeed on an unfair prejudice petition. The other case, OSC Distribution Limited, is a case where knowingly the directors promulgated a special resolution and they deliberately didn't notify a relatively significant minority shareholder, a 19% shareholder, where they knew that shareholder was likely to disagree with the special resolution sought. That was unfair to that member. As a member, you are entitled to receive notice of any special resolution. But notwithstanding that that was unfair, in the circumstances where the directors were trying to raise capital for the company and the other members thought that was a good idea, no prejudice, because even had that member been present to discuss that special resolution, their 19% objection would have made no difference whatsoever. So our next guiding principle when looking at unfair prejudice, make sure you've got both in place. If you have one but not the other, you'll fail on your petition. And a note of caution, which is in the handout but not on the slide. In the case of Hale and Waldock, Mr. Hale had allowed Mr. Waldock to run the company and had basically been a silent investor. And for reasons that are unimportant, having traded previously in partnership, he'd effectively ceased involvement with the company. And he decided that he now wanted more involvement and sought to suggest that his exclusion was unfair prejudice. In view of the fact that he himself had placed himself in the category of a silent investor, the court found that whilst there might have been some unfairness and some prejudice, where he'd for so long conducted himself in a way where he was entitled to be assumed to want to be akin to a silent investor, he couldn't then seek to bring a petition. So if you have someone come to you seeking advice on a petition where for a number of years they've not really been involved in the company, they may have put themselves in a position where they're unlikely to get a great deal of sympathy from the court. The next example is related to the doctrine of quasi-partnerships. Now, for any company, of course, you can have very different ways in which the company is run. And if you have a listed company where shareholders are likely not to know one another and are at some distance from one another, it is extremely unlikely that that company will run in any way other than through its articles of association and potentially through any shareholder agreement that's in place. A quasi-partnership, a classic quasi-partnership, would be something like a family business that initially has been run fairly informally, but at some stage it's been decided that they should incorporate, potentially for tax reasons, with a lot of that business done around the family meal table. Or a partnership where the partners have always dealt with things together and they've decided to incorporate. The test for a quasi-partnership remains and has stood the test of time. That's set out by Lord Wilberforce 50-odd years ago, where you look for one or more of a relationship of trust and confidence, classic partnership type relationship, an understanding that some or all of the members will participate in the conduct of the business of the company, and potentially restrictions on the transfer of shareholdings. Importantly, not necessarily all of those things need to be present. The benefit of establishing a quasi-partnership in unfair prejudice territory is it's far more likely then that conduct that is not on its face a breach of articles of association or a shareholder agreement, but conduct which is a breach of potential equitable considerations, shutting out of a director, is unfair prejudice. Deadlock is likely to be unfair prejudice in circumstances where you have a quasi-partnership, but far less likely to be established to be unfair prejudice in circumstances where you have a larger company that is definitely not a quasi-partnership. So what's not unfair prejudice? As I said earlier, a classic example of unfair prejudice is the exclusion of a director who's entered into a business understanding they'll be involved in the decisions. In remigration solutions, the director was excluded. But in that company, although it was said it was a quasi-partnership, it was held it wasn't at all. That company was one that was run in accordance with its documents. And so the fact that the director had been excluded, but there was no, on the face of it, breach of the documents that governed the way in which that company was run, meant that the individual member, director member, could not show unfair prejudice because they could not show a breach of the understanding that was the basis upon which that company would be run. Not unfair prejudice. Again, illustrating to us the importance of looking very carefully at the circumstances of the particular company, because on the face of it, I would hazard to suggest that if any of us received a set of papers where a director had been excluded from a company, our initial thought would be that's probably unfair prejudice, and illustrates why we need to look very carefully at the way in which that company is actually set up and run. Now, the last example that I want to give you is where there's been a fair offer. Now, in O'Neill and Phillips, Lord Hoffman explained the way in which you would go about making a fair offer to a minority shareholder in order to effectively ask them to exit a business. This is an incredibly important tactical tool in the sphere of unfair prejudice, because if you get it right as a company, as a majority shareholder, then you can prevent an unfair prejudice petition from being brought. That petition can be an abuse. Equally, if you are the minority shareholder's representative and you're seeking an exit, if you can work out what that fair offer should be, and you can show on the face of it evidence that suggests unfair prejudice, you're likely to be in a very good position in costs terms should you then have to issue that petition, because you've shown the company and the majority shareholder the exit route and they've chosen not to take it. So O'Neill and Phillips tells us that in order to get to the place of making a fair offer for fair value, you first of all have to ignore the idea of a discount for a minority shareholding. Normally on any valuation of shares, if it's not a share that means that you can dictate the way in which the company is governed, the shares are worth less. You have to abandon that discount. Next, you've got to have an independent expert. And Lord Hoffman said in O'Neill and Phillips that the obvious place to go for that would be at the Institute of Chartered Accountants. So if you can't agree between the parties who it should be, there's your avenue. Next, don't get into the idea of having an arbitration or provision of reasons or any sort of argument over the way in which that valuation has been reached. It should be for a valuation alone, because otherwise you are nailed on for satellite-type litigation. And last of all, in order to make that kind of an offer work, there must be equality of arms. So what you can't do is unilaterally go off and appoint an expert to carry out a valuation that looks like it's a fair valuation with no minority discount. If you're not giving that minority shareholder access to that expert to raise issues that they may have, or particular detail that they think the expert needs to take into account, you may find that you can't use that valuation in the way that I'm suggesting. If all of those things are in place and the offer is made to a minority shareholder who on the face of it could demonstrate unfair prejudice, the court should say that that petition is an abuse of process, because the remedy is already there and the shareholder can already get their remedy without the expense of court proceedings. And of course that's important because unfair prejudice petitions themselves can cause issues to the creditworthiness of a company. That's the reason that James referred to earlier on in his talk about winding up petitions, that you can't just tag on anymore a winding up petition, a just and equitable winding up remedy to an unfair prejudice petition as you used to. The practice direction says you cannot do that. The reason being, if that kind of remedy is on the face of pleadings, then it can immediately cause problems for the company's trading. So an example that I give you there, which illustrates this well, is a relatively recent case of BC&G care homes. Each of the three former partners had surnames that were B, C and G. It was not the most imaginative company name that you've ever come across. And they ran a care home business. Two of them fell out with the other. having had effectively a quasi-partnership. And as a result of them falling out with the other, they excluded the other from being a director, and he remained a director but couldn't make any decisions, and excluded them from involvement in the company. Now, in due course, that was held to be unfair prejudice. But in the judgment, what was said was, having removed that director in circumstances where it could be seen why that had taken place, because they were in hopeless conflict and realistically the company couldn't continue with the three of them making decisions, if the other two directors had made this kind of offer, an offer to buy out that director with no discount for the minority shareholding, it's highly unlikely that that petition could have got through to the stage of the remedy being ordered, which could in fact have been given before proceedings were even issued. So hopefully, in that, I accept, fairly whistle-stop tour, I've been able to give you some examples that sit around the edges of unfair prejudice, and areas where, if they do come to you, you will need to think quite carefully about whether or not it trips into the area of unfair prejudice, or whether you may need to be looking at a different sort of remedy.